I'm Stacy Cassidy, one of the attorney team leads at PartnerSource. I wanted to share with you an important case that just came out of the Court of Appeals in San Antonio last month. It's called We Deliver Inc. versus Calderon. And for those employers who are committed to fulfilling your duty to provide your employees with a safe workplace, it's a really important case. It involves an employee cook who was on his way through the kitchen to the freezer to get some items for a customer's order. On his way, he admittedly saw that the floor was wet, and so appreciating the risk, he carefully, while wearing slip-resistant shoes, walked through it and unfortunately fell and injured himself. Now, many of you may be thinking, I know how this story ends, or like a lot of defense lawyers at this point, thinking the duty to provide a safe workplace does not include a duty to warn employees of unreasonably dangerous conditions that are open and obvious or known and appreciated. I mean, think about it. What good would it have done to tell this employee, hey, the floor is wet, when he saw the floor was wet? Or, hey, be careful. He said he was being careful. He was even wearing protective equipment in the form of slip-resistant shoes to guard against injury. So under these circumstances, surely the employer does not owe that employee a duty. Well, the Court of Appeals said they do. They applied one of two exceptions to the general rule that there is no duty to warn of dangerous conditions that are open and obvious or known and appreciated. And we'll tell you more about how and why this applies at our first ever PartnerSource virtual conference. We hope to virtually see you there.